Okay, we are on the record now, and this is ANS Inc. versus LLPS Inc., docket number 20-96CB. And this is the time set for hearing on the plaintiff and counter defendant's motion for summary disposition. And if you would begin, please, by putting your appearances on the record.
Daniel Quick, appearing on behalf of the plaintiff, Your Honor.
Matthew Betcher, appearing on behalf of the defendant.
All right, thank you. And Mr. Quick, this is your motion. You may go ahead.
Thank you, Your Honor. Your Honor, I think it's a relatively simple issue before the court today, and it's probably received more than it deserves, and so I'll really just try to get the highlights. Both sides asked this court to make the call on summary disposition based upon unambiguous language in the so-called scrubbing agreement. And I think it's only logical that we start with the actual scrubbing agreement. It unambiguously defines at the very top of the first page who the parties, capital P, are to that agreement. And it only, in turn, in the substance of it, imposes obligations upon those same parties within the contract. This really ought to be the beginning and the end of the analysis as far as the plaintiff is concerned. And I'll note here that defendant does not or has not disputed in its response brief the legal authority we cited in support of the rather common sense proposition that when a contract states it's only between certain parties and imposes obligations only upon those parties, that only those parties need execute that agreement for it to be effective. If the court did want to go the next step and review the totality of the scrubbing agreement to make sure that if the court was interpreting it as a whole, it only further supports this conclusion. And without restating the details, at pages 5 and 6 of our motion, we cite several provisions which make clear that only outside of the monitor and the mailing house that ANS and LLPS are the parties to this agreement. All of the defendant's arguments face one logical inconsistency aside from the fact of the plain language of the agreement. And that is that under these various agreements, why would only Sheets be the unnecessary party, but not any of the other individuals who had signed the underlying settlement agreement? That question is not answered in the response brief, and it creates a logical inconsistency across all of the arguments that defendant has tendered. So, for example, I think the answer here really has two parts, and then I want to talk about the two arguments they raised in their counterclaim. The first answer is that clearly under the scrubbing agreement, no individuals are parties to it. They're not defined as parties, and even individuals like Steve Feda and Joe Feda, who were individual signers of the settlement agreement, are not parties, and on their signature blocks, it indicates that they are not signing individually, they're signing only as representatives of the corporate entities who are parties to the agreement. But there's also a logical reason why this is the answer. This scrubbing agreement is designed to effectuate a portion of the settlement agreement that permits these corporate entities to compete against one another. And I don't think I need to get into it because I think both sides have briefed it in terms of why what the scrubbing is supposed to do and why it's there. But logically, it only makes sense that since it's the corporate entity who is doing the competing, and it's the corporate entity whose customer list seeks to be protected against the other person's mailing, that those are the parties to the agreement and not the individuals. So both of the arguments that were originally raised in counterclaim seem to have been discarded along the way here because they're not really talked about in the response brief. The first argument, and this is in paragraph 43 of the counterclaim, was that section 4 of the settlement agreement required a party to the settlement agreement before they began to compete to participate in this scrubbing. Well, even if that's true, the only two parties who are actually doing the competing are ANS and LLPS. And thus, for that very reason, Joe Feda or Steve Feda or any of the other individuals who are parties to that original settlement agreement are not also signing or set up or even argued to be necessary signers for the scrubbing agreement. And the other argument that they made in the counterclaim, again, which seems to have been abandoned, is that under Section 22 of the settlement agreement, there was a provision normal in most agreements that says if any other document is reasonably necessary to effectuate the settlement agreement, the parties will sign it. Well, it's never been explained why it is reasonably necessary for Joe Sheets to be a mandatory signer on the scrubbing agreement at all, but especially when no other individual who was a signer to the settlement agreement is also being asked to sign that settlement agreement. And again, the simple answer to that is it's simply unnecessary because this is designed to be a protocol input between these corporate entities. The response brief did raise some other arguments, and I think really predicated largely on misrepresentation of the text of the underlying agreements. And I won't repeat what was in our reply brief, but we do feel strongly that the defendant crossed the line here from advocacy, fair advocacy, to intentionally misrepresenting the terms of these agreements. And we spent some time addressing those issues in our reply brief. But very briefly, Your Honor, there were essentially three arguments raised in that response, none of which hold water. The first was that the argument was an argument that based on the First Amendment to the settlement agreement, and that the argument that by Sheets signing the First Amendment to the settlement agreement, that he was binding himself and committing himself to also be a signer of the scrubbing agreement. That just simply isn't so based on the text in that First Amendment, and we spent time on that in the reply brief. But again, it runs into this logical inconsistency of, well, if that's so, then every other individual ought to probably have been a mandatory party to that scrubbing agreement, but nobody argues that, including the defendant, and that's because it just simply isn't so. The second argument they raise in the response is that the scrubbing agreement really is intended to be, and in fact is, an actual amendment to the settlement agreement. Well, that also is false. First of all, it doesn't purport to be an amendment to the settlement agreement. Second of all, the parties clearly know how to amend the settlement agreement when that's what they intend to do. That's why a First Amendment to the settlement agreement exists. And third of all, if in fact it was an amendment to the settlement agreement, again, it would have been structured like the actual amendment, meaning all of the parties to it would have been set up as signatories. That wasn't its function. That's not what it is. And then lastly, there is a little bit of a Hail Mary at the end of the response, suggesting, even though they strongly argue that they are also entitled to summary and arguing that the agreements are unambiguous, a suggestion really vaguely that somehow discovery ought to be permitted before the court rules. In our reply, we argue against that. There's no showing here that any quantum of discovery would contradict the unambiguous terms of these agreements or otherwise assist the court in its determination. So we would ask the court to grant our motion and order that the scrubbing agreement is effective. The ANS bargained for this right to compete. We're ready to proceed. We've already lost 4 months of our time, and we'd like to be able to proceed. Secondly, to dismiss the counterclaim with prejudice. And third, to consider an award of fees and costs as we put forth in the briefing.
Thank you. Mr. Batcher?
Thank you, Your Honor. I appreciate Mr. Quick's brevity. I'm going to try to be equally brief. This is a motion on the pleadings under C8, and for ANS to prevail, you have to accept everything they say is true, reject everything we say as false, construe all the facts against my client, construe all the facts in favor of ANS, and conclude as a matter of law that the parties never intended Mr. Sheets to be a signer of the scrubbing agreement. Mr. Quick focuses solely on the scrubbing agreement because he doesn't want you to look at the settlement agreement. He doesn't want you to look at the First Amendment, and he doesn't want you to look at the customer agreement. He wants you to construe a single document that's part of a larger group of documents that form the totality of the settlement, which we believe under the applicable law this court cannot do. the agreements must be read together, and the court must be able to conclude that they contain no ambiguity or lack of clarity such that the court can rule Sheets was never intended to be a party as a matter of law. In separating the scrubbing agreement from all the others, as if it were a wholly independent contract, we never really hear an explanation from A&S why this makes sense, why it should be treated independently of the others. I don't believe they can. In the same way that the customer list agreement was connected to the settlement agreement and the First Amendment, so too is the scrubbing agreement. Now, if Mr. Sheets was not expected to sign the scrubbing agreement, then why did he sign the customer list agreement if it's so superfluous? The fact is Mr. Sheets possessed a unique status in this dispute. He was a named party in the lawsuit. The other FATAs were not. Sheets was named personally, and that's why he signed the settlement agreement in his individual capacity, why he signed the First Amendment in his individual capacity, as well as the customer list agreement in his individual capacity. And this is precisely why counsel for LLPS asked Mr. Quick to make sure that Sheets also signed the scrubbing agreement, to make sure that he too was bound by that, and why Mr. Quick responded, quote unquote, fine. The argument we're hearing from ANS totally disregards Section 5C of the settlement agreement, which prohibits Sheets in his individual capacity from having any ownership in, working for, contributing any knowledge to any person, company, or other enterprise engaged in the marketing, sale, or fulfillment of the other party's protected products to the other party's existing customers. That's a duty much broader than you find solely stated in the original draft of the settlement agreement. And that's why the parties saw fit when December 2019 rolled around to create this new document in which they wanted to more greatly detail the parties' rights and obligations. Once again, Mr. Sheets is a party to the lawsuit. He's a party to the settlement. He enjoys all the benefits of that settlement, including the broad release that it included. And we've not heard any explanation why this is any problem for him not to sign the scrubbing agreement, other than he doesn't want to. Well, lawyers being lawyers, I can only conclude that there's something nefarious planned in the future. Either he's going to leave ANS and compete on his own, or there's plans for him to compete somehow independently through ANS, although I think that would be a failed effort. But there's simply no explanation why this is a problem, or why Mr. Sheets should somehow be excused from the scrubbing agreement when he willingly signed everything else. We look at the documents in total because that's the way the parties looked at the documents in total. And I spelled this out in our brief. The customer list the customer list agreement integrates the settlement agreement, which is integrated through the First Amendment. And Section 15 of the scrubbing agreement incorporates the prior two documents. So we don't think you can legally separate them out and look at that as if it were simply a standalone agreement, as counsel urges you to do. And mind you, and this is also something that I think is important to bear in mind, that the settlement agreement, which Sheets is bound to, speaks to the obligation of scrubbing customer lists. That's in Section 5. He also agrees to confidentiality in Section 4. We've argued, and I was attacked for making these arguments, that this was somehow misleading the court, that all of these documents should be read in unison, because that's the way the parties structured them. But the reality is the scrubbing agreement was integral to the parties' settlement agreement. It's what permits them to compete with one another during the extended restricted period that was supposed to start in January. Now, Mr. Quick makes it suggest that we're somehow foot dragging because we gained some sort of an unfair advantage by the delay. Well, nothing's farther from the truth, because we're hampered by the same inability to compete and market as his client is. We just want everyone bound and playing by the same rules as was agreed to when the settlement was originally structured. ANS is asking to disregard the language in the First Amendment in which the parties who all signed it said that it would be effective and duties would come into play, quote, upon all parties having signed the agreement. Now, because that has a lowercase p in the word parties instead of a uppercase P, we're once again being accused of trying to mislead the court. Well, we didn't transpose letters. The court is reading these documents the same way we are. We're just making the argument that everyone having signed it must have agreed to be bound by it. The level of the vitriol thrown at my client and myself personally, I was more amused than offended because frankly, the level of vitriol that I see in an argument is generally, in my experience, directly related to the weakness of the contra argument to my position. This is a C8 motion based on the pleadings. Now we put in our brief the option for this court to grant us summary disposition under 2.116 I2, because we frankly think reading all of these documents together, which we believe the court must do, leads to the conclusion that Sheets is a party and he should sign. However, if you can't grant summary disposition for my client, you certainly can't grant summary disposition for ANS and rule as a matter of law that he was never intended to be a party, because that's just simply not what the parties are saying in any of the documents and in our complaint in the briefs. So I think the matter, I agree with Mr. Quick. I think the matter was probably briefed to a degree greater than we would normally see in this case. We're both asking the court to do the same thing, which is to construe documents as a matter of law if possible, but if not, to identify that there is a question of fact as to the party's intent and let us proceed as we should. But we believe that when you read those documents all together, you should grant judgment for LLPS against ANS. And we would ask you to do that. Thank you.
Thank you. Mr. Quick?
Thank you, Your Honor. Just very quickly, I think each of these arguments is easily refuted and again shows this troubling penchant for taking liberties with the underlying contractual language. So let's start with the legal standard, and this is something that I don't need to dwell on because I know the court is well familiar with it. While it's a C8 motion, the issue on contract interpretation is that if the contracts are unambiguous, the court can rule on that as a C8. So it has nothing to do with construing facts in the manner alleged by the plaintiff. It has to do, in the first instance, with are we faced with an unambiguous agreement? And if so, what does it mean? And here we believe the only way that the intent is derived is from the four corners of the agreement, and that speaks very clearly to the question. Secondly, the comment generically that the contracts need to be read together, as we demonstrate in the reply brief, I hear that argument, but I don't know where it gets them. So for example, it's a complete fallacy to say that the scrubbing agreement, which was drafted in 2019 and signed in 2019, was contemplated, and I quote counsel, as integral to the settlement agreement signed several years prior. That's a complete fallacy. The court will find no reference to a scrubbing agreement anywhere in the settlement agreement that was signed back in the day. In fact, it says the opposite. Section 5 of the settlement agreement says that the scrubbing will take place pursuant to the procedures provided below. And it specifies in sections 5A, B, and C how that scrubbing is supposed to take place. So the scrubbing agreement was not contemplated at the time of the settlement agreement, or at least on this record and on the unambiguous language of the contracts, there was no support for that argument. But it's also a red herring, because there is nothing in the scrubbing agreement that in any way contradicts the settlement agreement or contradicts the other sets of agreements that were executed between the parties. That's where this doctrine would normally come into play when someone says, hey, all of the contracts on the same subject matter need to be looked at together. So it's not an issue of interpreting the contracts vis-a-vis one another that there's some conflict. They simply want to try to import the parties, one of the parties, from the settlement agreement into and make him a mandatory party on the scrubbing agreement. But simply saying that things should be construed together doesn't get you there. And I'll note, counsel never answered the question that I posed very clearly of, under all of these different arguments, what logic is there conceivably to arguing that Sheets and only Sheets is a mandatory signer to the scrubbing agreement, but all of the other individuals, and I'll correct counsel, and I know you misspoke accidentally, Steve Feta, Joe Feta, Tom Feta, all these parties were parties to the underlying settlement agreement and the underlying litigation individually. None of them are purported individual signers on the scrubbing agreement. Next, Your Honor, there is an argument, and this I really sort of just spoke to it, the argument that Sheets somehow has a unique status. Again, that's false. He has no unique status. He was one of several individuals who signed that underlying settlement agreement. And he is no more in violation of this Section 5C of the settlement agreement than anybody else. That provision has nothing to do with the scrubbing agreement. So Steve Feta, who is the owner of ANS, who works for ANS, he's going to be involved in ANS executing this competition, yet nowhere does defendant argue that Steve Feta is supposed to be a signatory, but somehow Sheets is. No legal basis for that argument on these contracts. Lastly, Your Honor, this First Amendment argument, I do not want to beat the horse on this because I know we spent time on it in the reply brief. The argument that counsel made or defendant made in that response brief as to the First Amendment was that the First Amendment to the settlement agreement actually compelled Mr. Sheets and was a commitment by Mr. Sheets to execute the scrubbing agreement. That is a blatant, it's complete fabrication based upon the language. There is no language in that agreement that says that. And there is nothing in that agreement that says that the First Amendment only becomes effective once the scrubbing agreement is executed. Rather, the unambiguous language in that First Amendment is simply that Romkema, who was the monitor, will deliver these existing customer lists upon all parties, small p, having signed this agreement and the scrubbing agreement. So it was simply a time, it was a trigger. Romkema, when everyone is signed up on that scrubbing agreement, that's your time to deliver those lists. But it didn't define who the everyone was to the settlement agreement or to the scrubbing agreement. And in fact, I would argue that because it uses the small p, and the parties were careful when they drafted these documents, that it recognized that there were different parties involved to one agreement versus another. For all the reasons we set forth previously, Your Honor, we'd ask you to grant the motion.
Okay, thank you. Well, a little background first, because it's not all that uncomplicated. There are a number of different contracts that the parties have argued about here. The issue in this case, though, the issue of what's before the court is the enforceability of what's called the scrubbing agreement. And the plaintiff says that it's fully enforceable and is asking that it be enforced. The defendant says it's not enforceable because it was not signed by Joseph Sheets, an employee of ANS. The scrubbing agreement is made between three entities: LLPS Inc., which is a Michigan corporation, and the agreement refers to LLPS Inc. as MPA, based on its former name. And then the second entity is ANS Inc., a Michigan corporation, and Promax Enterprises, a Florida corporation, who are both referred to together as the ANS Group. And then a third entity, Trans-American Direct Inc., a California corporation, which is a mailing house. So two of those groups, MPA and ANS, are expressly stated in the agreement as the, quote, capital P parties. Trans-American, although it's a signatory to the scrubbing agreement, isn't included in the definition of capital P parties. Just on its face, the scrubbing agreement reveals no reason why it would not be enforceable. Joseph Sheets is not a party to the scrubbing agreement, and he's not even a principal of ANS. As an employee of ANS and as someone with no obligations under the scrubbing agreement, there's no reason to conclude that his signature was necessary to make the agreement enforceable. However, there were 3 agreements that preceded this scrubbing agreement. The first in time was the settlement agreement that settled a previous lawsuit. The settlement agreement did involve Joseph Sheets individually, as well as Stephen Fata, F-A-T-A, individually, together with ANS on the one side, and then on the other side was LLPS and other individual Fata family members. Then after that came the customer list agreement, again between Joseph Sheets, Stephen Fata, and ANS on the one side, and LLPS together with individual Fatas on the other side. Then came the First Amendment to the settlement agreement and customer list agreement by and between those same entities and individuals. And then finally, what we've mostly talked about here today, there is the scrubbing agreement that includes no individual signers. One of the defendant's arguments is that the scrubbing agreement was actually the parties' amendment of sections 4 and 5A of the settlement agreement, and that it provides more detail when describing their respective rights and obligations under the settlement agreement. However, the court finds that the very terms of the scrubbing agreement contradict that argument. First of all, Section 15 of the scrubbing agreement provides in part that, quote, this agreement does not supersede or amend the parties' settlement agreement and customer list agreement, end quote. The defendant's argument is also contradicted by the fact that when the parties to the settlement agreement, in fact, wanted to amend that agreement, they specifically did so by executing the First Amendment to Settlement Agreement and Customer List Agreement. The parties to the settlement agreement also demonstrated that they knew how to amend it by having the same parties that signed the settlement agreement sign the First Amendment to the settlement agreement. And the same cannot be said of the scrubbing agreement. Now, I realize that could be interpreted as a circular argument because the defendant's position is that Joseph Sheets should have signed the scrubbing agreement. However, none of the individuals who signed the settlement agreement signed the scrubbing agreement. It wasn't just Joseph Sheets who was missing, but the individual Fata individuals as well. Finally, the defendant's argument that the scrubbing agreement describes in more detail the parties' rights and obligations under the settlement agreement is refuted by the fact that Joseph Sheets was a party to the settlement agreement, but no rights or obligations of Joseph Sheets are addressed in the scrubbing agreement. So I have to reject the argument that the scrubbing agreement was some kind of an amendment of the settlement agreement or a further description of the parties to the settlement agreement's rights and obligations. But the defendant also argues that all parties to the First Amendment to the settlement agreement agreed to sign the scrubbing agreement. And the defendant does make that argument by blurring the distinction between capital P parties and lowercase p parties in the First Amendment. It is a distinction that was carefully made. If you look at the recitals section of the First Amendment, where it states any capitalized terms used herein but not otherwise defined will have those meanings as provided under the settlement agreement and customer list agreement, end quote. The First Amendment states, Romkema, I'm not sure if that's mistyped, if that's really the name, but it's R-O-M-K-E-M-A, shall deliver the existing customer lists in his possession to both Peachtree and the selected mass mailing vendor upon all, this is lowercase p, parties having signed this agreement and the scrubbing agreement. The reference to lowercase p, parties signing a scrubbing agreement, cannot refer to the parties to the settlement agreement because those are the uppercase p parties, a distinction that the contract was careful to make. The defendant also points to other language in the First Amendment in support of its argument that the parties agreed to all sign a scrubbing agreement. That language that the defendant points to says, quote, Peachtree will assume all of the obligations and responsibilities of ROMCMA as provided under the settlement agreement and the customer list agreement immediately effective on the execution of this agreement and the scrubbing agreement, end quote. That language is not an agreement for all the parties to the settlement agreement and the First Amendment to sign a scrubbing agreement. By its very plain language, it is an obligation by Peachtree that takes effect when a scrubbing agreement is signed. Next, the defendant points to the integration clause in the scrubbing agreement as evidence of its position. Neither the integration clause of the scrubbing agreement nor the principle that contracts of like subject matter should be construed together leads to the conclusion that the scrubbing agreement is unenforceable without Joseph Sheets' signature. If anything, the integration clause completely cuts against the defendant's argument because the integration clause carefully distinguishes between the agreements between MPA Group and the ANS Group, which would be the settlement agreement and the First Amendment, and the agreement between the other lowercase p parties. The rule that contracts of the same subject matter are to be construed together also changes nothing. I have construed these contracts together as is required, and together they evidence that Joseph Sheets was not a party to the scrubbing agreement, had no individual rights or obligations under the scrubbing agreement, and that the scrubbing agreement was not an amendment to the settlement agreement. Finally, the defendant argues that summary disposition is premature at the pleading stage, and it should be denied until the parties can conduct discovery. However, the defendant has also argued that it is entitled to summary disposition under I-2 because the contracts are clear and unambiguous. The contracts are clear and unambiguous, and as such, this matter can be decided as a matter of law under C-8 without discovery. It is the plaintiff and not the defendant who is entitled to summary disposition for the reasons that I've just given, and I'm granting the plaintiff's motion for the relief requested of a declaratory judgment that the scrubbing agreement is effective as is, and that the defendant's counterclaim should be dismissed with prejudice. I'm denying the request for an award of sanctions. And Mr. Quick, if you'd like to submit an order under the 7-day rule that just indicates that and for the further reasons stated on the record.
I will do that, Your Honor. Thank you.
All right, thank you. Then that will conclude our hearing.
Thank you, Your Honor.
Thank you.